And now, our feature presentation.
The lawyers and judges use the words, which some may find offensive.
Please be seated. Just one or two housekeeping matters. Judge Sack was a member of this panel but recused himself. We're joined by Judge LaValle. After we hear argument in the first case, we will adjourn for 10 minutes so that Judge Sack can join us for the balance of the calendar. The second matter is I left it to the parties to divide up the time allocated, and I assume they've done that. So let me call Fox versus FCC, and we also have, I see on the calendar, CBS and NBC as interveners arguing. So will Fox take the podium?
Good morning, Your Honor. Carter Phillips representing Fox Television. I will also be the only counsel arguing on our side in this case. In 2002, the renowned actress and singer Cher responded to her critics in a television show by saying, "Fuck 'em." And in 2003, Nicole Richie, who is an actress, commented on her own television show, which is entitled The Simple Life, by saying that it was hardly all that simple, because does anybody know how hard it is to get, how fucking hard it is to get cow shit out of a Prada purse? And,
did Fox plan those?
No.
Those statements?
No, there's no dispute that Fox did not plan them. The only assessment by the FCC is that Fox was arguably negligent in failing adequately to respond to the possibility that those statements might be offered. But
would it have made a difference if Fox knew in advance? Will you concede that?
Well, it would have satisfied the intent standard that we believe is appropriate under the statute, but it still, from our perspective, it still wouldn't make this conduct indecent.
And both of those award shows were on the air before the Golden Globes order. Is that correct?
Yes, both of them predated the Golden Globes order. So as of that point in time, we have 30 years of unbroken precedent where the Commission recognizes, obviously, that the use of these expletives is offensive to some, but has never declared that the use of these expletives is a basis for any kind of a sanction. I mean, we start...
Let me just say a word. First, let me ask you all to recognize that the acoustics in this room are terrible, so okay. Please speak good and loud, emphatically and clearly. I don't see why, I don't understand why Fox's knowledge or lack of knowledge really has anything to do with the question whether what comes out on the air is indecent or profane.
Oh, I agree
it may have a lot to do with whether a penalty should be imposed, which was not imposed in this case, but you would agree, I take it, that planned or unplanned has nothing to do with whether the content is indecent.
Right. I think if it's scripted and intended to be put forward on the air, there's still the fundamental question as to whether or not the particular words can be declared to be indecent, and then after that, obviously, you go into the question of intent.
Or if they're integral to the work, then they may be found not indecent, like Saving Private Ryan.
Right. There's no question that the Commission has a basic approach that says that we will presume that the use of these particular expletives, fuck and shit, specific words, is presumptively indecent, and then you have the opportunity to come in and try to rebut that presumption by saying that there is some contextual basis for supporting it. But, you know, obviously the creation of the presumption in the first instance is a complete departure from any notion of context, because it's saying these are words that are categorically barred, which is something the Commission has never said in 30 years of enforcement of indecency.
Well, the words are the same. The regulation is the same that's been in effect, hasn't it? It's just, it's a different level of enforcement.
It's a demonstrably different level.
But
And
it's not new words. They always, and these are the words that have been used in other contexts as well. It's the barring of the reference to sexual and excretory.
Mommy, I was looking up pictures of cats and saw naked ladies. Why doesn't someone filter that from my young mind?
Well, the Communications Decency Act was placed to regulate pornographic material on the Internet. It had provisions that made it a crime to send offensive Internet material to people under 18.
So why'd they get rid of the act?
In 1997, a group of organizations, including the American Civil Liberties Union, challenged the provisions in the CDA. They said it violated the First Amendment's right to freedom of speech. The Attorney General Janet Reno appealed to the Supreme Court. The case was called Reno versus ACLU. This was the first case involving cyberspace.
So what happened?
Both provisions were voted against by the Supreme Court. Justice John Paul Stevens wrote an opinion in which 6 other justices joined fully.
What was the opinion?
Justice Stevens said that it was too hard to verify the age of an Internet user. The Act didn't define what indecent Internet materials were and didn't allow parents to authorize their children to access the indecent materials. The regulated materials don't just appear on a computer, so they must be actively sought out.
Wasn't there anyone else to argue with him?
Well, Justice O'Connor thought that they should make adult zones of the Internet, but thought it was impossible to do, so she agreed with the majority.
Why couldn't they make an organization to keep my mind free from impurities?
Well, in 1968 there was a court case called Ginsburg versus New York that said that material may be harmful to children even though it isn't obscene. Federal Communications Commission versus Pacifica Foundation in 1978 gave the FCC the right to censor broadcasts during times that children should be awake to keep them from harmful material.
Shouldn't the FCC regulate the Internet too?
The Internet isn't a scarce commodity like radio or television, so the Federal Communications Commission can't regulate it. If child-blocking technology and age-check systems become more effective and are used more widely on the Internet, a law like that might be upheld in the future. But until then, I'm going to have to watch what you look up on the computer.
But Mom.
No buts. Now go upstairs and do your homework.
Today we'll be talking about what should and shouldn't be shown on TV. You know, like your violence, curse words, nudity, those fun things that kids shouldn't really see. There's a couple of cases that were taken to the Supreme Court because the people who brought them there thought that they had their freedom of speech violated. First one is Playboy Entertainment Group versus United States, and another one is FCC versus Fox Television. The Telecommunications Act of 1996 required cable operators to fully scramble or otherwise block channels that are dedicated to sexually oriented programs. Playboy Entertainment Group challenged the statute as being unnecessarily restrictive and therefore a violation of the First Amendment. The District Court agreed that a less restrictive means existed for effectuating the same goal, allowing households to request blockage of these channels. The United States thus filed a direct appeal to the Supreme Court. The government, in effectuating content-based legislation to limit speech that is protected in the First Amendment, must do so through least restrictive means for government interest. The Telecommunications Act of 1996 included a section, Section 505, that required cable television operators to provide channels primarily dedicated to sexually oriented programs to either fully scramble or otherwise block those channels. Or what we can also do is limit their transmission to hours when children unlikely view them. Those hours are between 10 p.m. and 6 a.m. The purpose of Section 505 is to shield children from hearing or seeing images that are bad for them. And that's called like signal bleed. The Playboy Entertainment Group challenges that statute as being unnecessarily restrictive content-based legislation that violate the First Amendment. The District Court concluded that a regime in which viewers could order signal blocking on a household by household basis prevented as ineffective and also less restrictive alternative Section 505. This less restrictive mean is known as Section 504, which requires a cable operator, upon request of a subscriber, to fully scramble or otherwise block that channel that the subscriber does not want to receive. The United States appealed directly to the Supreme Court seeking to have the judgment reversed. Basically, the issue of that is, in Section 504, which regulates speech is based on its content narrowly tailored to promote a compelling government interest? Is there a less restrictive alternative to Section 505 to effectuate the government's purpose? And basically what I think, those programs are sexually oriented. Nowadays, you have to specifically order those. Like I'll show you on my dish remote. Those channels are also quite far up there. You have to go all the way up to like channel 480. And you have to pay for those. So you know what you're getting when you buy those, and you can hide those from your kids. And also, on dish remotes, I don't know about any other cable providers or dish providers, those have parental controls on them. You can set those to a certain range that the kids can't see. So if the kids have like TV in their room, you can program the remote with a password on it, so they can only see stuff to a certain rating. Anything above that will block them out. That's about as far as I think the government should really go with that. And those channels like HBO, those movies, you have to pay for those channels as well, but those movies are also a bit more graphic in what's in them because those channels aren't regulated like regular channels like USA or Fox. Those channels can only show whatever they want because you have to pay for those, and most of those movies are rated R, which you know what's in them.
Because the FCC failed to give Fox and ABC fair notice prior to the broadcast in question, that fleeting, explicit, and monetary nudity could be found actionably innocent, the FCC's standards as applied to these broadcasts were vague.
But the pretty much what this says is, in 2004, the FCC commissioned the government agency that regulates radio and television stations, and sometimes those stations' actual networks, changed its policy of what it considers indecent, and thus could not be put on the radio or TV between 10 a.m. and 6 p.m. because children might be watching or listening. Before 2004, the FCC banned vulgar, four-letter words only if they'd been repeated over and over and over again. With the change in policy, the FCC said it could ban even a single fleeting use of such a word during the daytime hours, which I think is ridiculous. It later said that it also banned even momentary glimpses on TV of a nude body if it was shown in a sexually provocative way. The Supreme Court was asked in this case to decide whether or not it violated free speech rights to the radio and TV stations and their networks, and for the FCC to impose such a broad ban. In deciding the case, however, the court did not settle whether the FCC policy violated the First Amendment. Instead, it only held that only broadcasters had constitutional right to be warned in advance of what the new policy prohibited, and the FCC had imposed its changed policy after broadcasts already aired, rather than before. The FCC now has the option of reconsidering its policy or keeping it as is and awaiting a new constitutional challenge in court. The court's ruling was unanimous by vote, but Justice Sonia Sotomayor did not participate because she had some involvement with the case earlier when she was judged on the Second Court of Appeals in New York. Basically, if you're going to use curse words on TV, you should know about it ahead of time and be prepared to delete them. And just make sure you say there's any curse words in it. And it should be that restrictive on TV.
My opinion is, if you don't want your kids to watch the explicit TV shows, don't even turn them on. I mean, it's common sense, people. If you don't want your child to pick up on cussing and seeing all this nudity, violence, just don't watch it when they're up. Watch it at night when they're asleep.
Or use that DVR that you paid for.
Just, it's common sense, people. If you don't want your kids to see it, just don't show them.
And if you want to be a really good parent, you do this ahead of time. Otherwise, if your kids see this on your TV and you didn't do anything about it, you just weren't a very good parent. So if you want to be a good parent, block this stuff for them, and when they get old enough to watch it, then you can unblock it for them. So basically, if you don't want your kid to see it,
don't show it. End of story. It's easy as 1, 2, 3.
That's it.
Should and shouldn't be shown on TV, Quincy?
I think there should be more about ethics and morality and less about consumerism and just throwing ads in your face all day. And more about just like love and family. It's about material stuff.
Alright. Thanks, Quincy. It shouldn't be shown on TV, Colin.
Well, most shows these days are rated PG-13, so their general directed audience is for kids who are 13 and above with parental guidance, but they make kids shows, so, but, you know, there's a rating, so, you know, they got X, R, you know, so on and so forth. So it all depends on the show's directed audience, but I watch a lot of shows, like Family Guy, and blah, blah, blah. It just generally depends on the show's directed audience. But mostly, if a parent is doing their job, they won't let their 3-year-old child watch, you know, South Park or stuff like that.
What should be shown and what should not be shown on TV?
I think the only thing that should be shown on TV is happy stuff. No violence, no criminals, no death, comedy. That's it.
Alright. What should be shown on TVs?
What should or shouldn't be shown on
Yes.
TV? I guess one thing that I like that seems to have been fallen by the wayside lately is that it used to be that some of the bad language and adult situations